And action.
Hey, thank you. All righty. We're finished with condominiums. We're going to talk about cooperatives. How does a cooperative look any different from this?
They don't own the individual building.
Now, how does it look any different from this picture?
No, I don't think it looks any different. I don't think it would look any different.
Good. That's the important part to know.
I'm just messaging them really quick to tell them, hurry up.
They look identical. You drive by one building, it's a condo. You drive by next building, it's a co-op. No way to tell. All we're talking about here is a different ownership structure. Significantly different, but yet a lot of the concepts are the same and much shorter and less complicated. In a co-op, very simply, one corporation owns everything, owns the land and the building, 100%. Corporation owns everything. When you buy a co-op unit, you're buying stock in the corporation. As you recall, and a condo association has members, but a cooperative corporation, you are buying stock. And every person who, we'll use the term loosely for a moment, owns a unit, is a stockholder in the corporation that owns the building. So what you get when you buy in a co-op is you get stock ownership in the corporation that's going to operate the building, and you get one more thing. You get a proprietary lease to your apartment. And what that means is, proprietary lease indicates that you're actually an owner, you're a part owner of the landlord, because you're a stockholder of the corporation that is the landlord, and you're the tenant. Obviously, the lessor, the landlord on that lease, is going to be the owner, the cooperative corporation, because it owns the land in the building. And the so-called unit owner is going to be the lessee. And there is rent payable every month under that proprietary lease, but the rent is the amounts necessary to pay the building expenses. So in that sense, there's a similarity. But here your payments are rent. As cooperative corporation stockholders, you run the corporation, you elect a board, you have officers, you do all that kind of stuff, and you're a stockholder, and you're a tenant, which means a lessee on a proprietary lease of your individual apartment. That's a co-op. Now here's the big difference in the practical sense. There's going to be one big mortgage on the whole building. And a part of the rent you pay is going to go to making those mortgage payments. It's not impossible, but it's rare and it's complicated that you'd have an individual mortgage on your apartment alone. It's doable, but it's rare. Since there's one big mortgage and you're each paying part of the mortgage payments and your rent, and it gets pretty scary when a bunch of people aren't paying. In a condominium, maybe you got some issues with the water bill and the lawn man and maybe even with the insurance. But in a co-op, a lot of people stop making their payments to the cooperative association. It stops making payments on the mortgage, and the lender forecloses on the whole building, on everybody's apartments. There's no separate mortgage on your apartment alone. Yes, ma'am.
Co-ops seem a very antiquated structure. So what happens when there is no mortgage on the building? What, you know,
What happens when the what mortgage on the
there
building?
are, when the mortgage is paid off on the co-op? Don't they-
Great, then there's no mortgage.
So when I buy a co-op, where would my money go? I would just be a shareholder of the building?
Well, when,
Still pay the fees.
when you buy a co-op, you're buying stock in the corporation, okay? When you buy from the original cooperative corporation, you're paying it for stock, and it gives you an ownership interest by stock, and it gives you a proprietary lease on your apartment. When you buy from an individual owner, here's what happens. A resale. The stock certificate in a cooperative says this stock may not be transferred, period. Excuse me, it can only be surrendered back to the corporation and reissued. So when you buy in a co-op, the seller turns his stock certificate back into the corporation. The corporation and cancels his proprietary lease of the unit. The corporation issues a new stock certificate to you, the buyer, and the corporation issues a new proprietary lease to you, the buyer. Now, the question is, how does the seller get his money out of it? You pay the seller a certain amount of money to induce him to turn his stock back in and cancel his lease. But the documents that you're getting to evidence your ownership, different from a condominium or different from any other type property, are not coming from the guy you bought from. They're coming from the corporation that owns this building. When the mortgage is all paid off, as you said, everybody's rent's going to go down a lot, right? Okay, now, if you want to, if we all as stockholders get together and agree, let's go out and get another mortgage. You can do that. We divide up all the money. Maybe let's go get another mortgage so we can add a second swimming pool. Put in a swimming pool, we all get to use it, but of course, we all have to pay 8.5% of that mortgage payment every month. But if the mortgage is gone, that portion of your rent under your proprietary lease, which you used to have to pay because it was a mortgage, you just don't pay it anymore. But nobody pays it. Nobody in the building pays it. Now, there are all kinds of little permutations and gimmicks, like it may be that in order to pay the person that you bought the apartment from, you may have given a promissory note to that guy for the amount of money. So you may still have a payment to him. But what we're talking about is the co-op's mortgage on the entire building and on the land itself. When it's gone, it's gone, if they don't refinance it.
Why are co-ops popular in New York? I mean, it seems like every unit in New York is in a co-op versus a condo. Why is it so popular up there?
I don't have a good answer for that. It used to be, before we had the concept of condominiums, that every building that was set up for separate ownership of apartments was a co-op. And of course, part of the reason may be because some of these buildings in New York are 100 years old, and that's how they were set up originally. And they just continued that way. Newer buildings, nobody's building new co-ops today. It's not considered to be attractive. People want to have their own mortgage on their own unit and not be a part of a big mortgage on the whole building that we can all get in trouble if a few guys don't pay. And get in trouble, everybody's going to have to cough up because nobody's going to let it all go. At the risk of complicating things, but let me just say, you can convert a cooperative building to a condominium. It is doable. And some of the older cooperative buildings, everybody's getting together and deciding, you know, wouldn't it be better if we were a condominium? And they can do that. every single person in the building has to agree, 100%. Because every person has to agree to turn in his proprietary lease. And what would happen basically, if you think it through, everybody says, okay, I'll turn in my stock certificate and I'll turn in my proprietary lease, and then the corporation becomes the developer and it files a declaration of condominium, and then it deeds back to each guy his unit, and then each guy can go get his own mortgage on his own unit. But the problem is, just like anything in life, everybody's got to agree, and there's always some idiot who's not wanting to pay his 8% of the attorney's fees or the cost of doing this, you know, and you can't do it. But I have never seen anybody want to convert a condominium to a co-op. But I did want to make that point that it is doable in the old co-op buildings to convert them to condominium. Unfortunately, it takes 100% approval. All right, that's basically it for a co-op.
It may also be,
Yes.
I was saying, it may also be to maintain a certain level of exclusivity in certain buildings.
Level of what, I'm sorry?
Exclusivity in certain buildings, you keep certain people out by doing it that way. Not because you have the money means you can buy it.
Okay, exclusivity in that sense. I thought you meant exclusivity and like snob appeal. Being exclusive as to turning people down. Yeah, theoretically, the cooperative corporation can exercise more discretion, for lack of a better term, in terms of its ability to keep people out. Because it's actually sort of the seller. It's issuing the stock and it's issuing the lease. That is possible. But you run into the same issues, where the guy who had a unit wants to sell it to somebody, and if the association doesn't want to, the cooperative corporation, you're queering his deal, and he's losing the benefit of a deal, so there's a chance there's going to be litigation arising out of it, and you still end up with the same kind of messes. It's just, I think frankly, you're right, the cooperative corporation has a better defense because it's actually a party to the transaction, as opposed to the condo association that's just sitting out there rubber stamp on approval.
On the side.
Okay. There's a special special type of condominium that I want to spend only 30 seconds on, but you need to know it exists. It's called a timeshare. Probably heard of them. What it really means simply is, and how they work in Florida, they work in weeks. You buy the 17th week every year of Unit 202. It's still a condominium. Of course it's furnished, because it wouldn't make any sense if it weren't. Because really they're 1 week vacation homes. And you buy a week or 2 weeks or 3 weeks, and of course there are all kinds of exchange markets out there and organizations that swap your week on Fort Lauderdale Beach for a week on the mountains and ski slopes in Colorado. I mean, there's all this stuff going on, but that is a type of condominium, and I think that's enough said. You're buying a week, the right to use it for a week. You still pay assessments, you still have association. Your right of occupancy is for your 1 week of ownership. All right. There's one more concept that's at the back of this chapter that I want to touch on a little bit, but say basically that we're not going to get into it. And it's a concept that Irene brought up before, all about a security. A security is like buying stock. A security is an investment. The courts have defined a security as an investment contract where you enter into a contract with the expectation of making money. Now, if condominiums are marketed like a security, they can in fact be a security as defined under the security laws. That triggers all kinds of scary stuff. If condominiums are marketed by a developer with pitches like, we'll manage your unit for you and you'll make a lot of money. This is a wonderful investment because you're going to have all this income when we rent the apartment out, and we'll handle all the expenses, and you'll make a ton of money just like if you invested in the stock market. That makes it a security. And if it's a security, that triggers all kinds of registration requirements under federal law and under Florida law. And there are exceptions to these for sophisticated investors and the small size groups, and there are all kinds of ways to get out of the security law. But conceptually, if you market a condominium unit as an investment, you stand a great chance of triggering the application of the Federal Securities Act of 1933 and 1934, which requires registration and the prospectuses and all these nasty things that are involved with selling a stock. And Florida has similar laws. State laws on securities are called blue sky laws. And they, of course, got that name from dealers promising blue skies and happy days and wonderful returns on your investment for everybody. And so state laws also require registration. As far as I want to go is to say simply, if you ever get involved in selling condominiums as investment contracts, as vehicles to invest your money and probably have a wonderful return because we're going to rent them out and make you a bunch of money, you probably got a security, and you need to be talking to a securities lawyer. Because if you go forward marketing a project like that without covering the securities law implications, all kinds of stuff. Not only civil penalties of shutting you down, but criminal penalties. It's a crime to market a security without proper registration. But the regular sale of a condominium unit, as a, here, buy this wonderful unit, it's a great home for you, that's fine. That is not a security. But as an investment vehicle to generate income and et cetera, it is. Yes, ma'am.
So the hotels that sell units as condos that can be rented out, what would those be classified as?
You talking about timeshares?
No, I'm talking
Condo
about like
hotels.
Canyon Ranch, you buy a condo there. You own it for the year, but then they rent it out 9 months out of the year for you.
If it's put into a rental pool where somebody manages it for you, that's
Yeah.
probably a security. If you yourself decide to rent out your unit and list it with a broker, that's all fine. You know, you still gotta get approved by the board and all that kind of stuff. The problem is when somebody comes to you and says, I'm gonna manage this for you, I'm gonna handle the marketing of it, I'm gonna handle the leasing of it, I'm gonna handle the expenses, the maintenance, the income, and you're probably gonna make a bunch of money, that's a security. Because it's an investment contract. There's nothing wrong with buying a unit yourself for investment purposes, thinking you'll lease it out. That's cool.
No, but in hotels they do that, where they
They-
like sell, do you know what I'm trying to say?
Yes, and the answer is, if a broker or a salesperson tells you that you're gonna make 8% return on your investment because it's in the rental pool, then that broker is committing fraud, is a security, he cannot do that.
Okay.
After the crash of 2007-8, all the brokers were forbidden by the developers to provide that kind of information to their prospect buyers because they were getting sued by the buyers and saying that they wanted out of their contracts because they were offered a security. And that happens in the Trump in Miami, that happened in Canyon Ranch, in Wamba Harbor, etc.
Yeah,
But we're not saying you can't do that.
yeah.
You can do it. You just have to register it as a security with both the federal government and the state government. And those obligations and requirements are extremely oppressive and expensive.
Very expensive.
And that normally means just don't do it. But it does happen. There's no question that you can buy a condo unit and Marriott Hotel will manage it for you and will put people in there on a daily, weekly, monthly basis and all that. It just happens to be a security. But if you bought it from an individual owner who didn't pitch it to you as an investment, if you just plain old bought it, that's just fine. An individual sale without, basically without marketing hype as an investment is fine. And that's as far as I want to go with that. The materials go on into what are all the exemptions, what are the, we don't need to know all that. The point is, if you get into something like this, if you're the guy, the company you're working for decides to do one of these, or you decide to do one of these, go see a securities lawyer. Just that simple. Go see an expert and make sure that you're following one of the exemptions, and there are some exemptions, but they have all kinds of little rules, and you gotta really dot a lot of I's, cross T's, and be real careful who you market them to, and how you market them. Maybe you're exempt, but if you just charge off out there putting out brochures about, boy, this is a great investment, you're gonna make a ton of money, and you don't cover yourself on those issues, serious problems. Not just shut you down, but civilly fine you and criminally prosecute you under the securities laws. Okay.
Plus fish.
Um,
Got it? Plus fish.
We're gonna move into an area now that has 2 chapters on it. And as you know, leasing, and yes.
Does that mean that as it relates to exemptions and to the end of the chapter, we skip that
We're
for the
finished with
meeting?
that chapter.
Yeah, but for the test, do we include that section or no?
Kinda like I said before, if we didn't talk about it, you're not responsible for it. If I said to you, is it possible for the sale of a condominium to be a security? Yes or no? But not, what are the exemptions, how do you register, no way.
Okay.
That's a whole class in securities law, and we're not talking about that, we're talking about real estate law.
You're more
Yes,
than
sir.
welcome to use that question.
So as,
I'm sorry,
I say you're more than welcome to use that question. And
We're on it.
as a beginning developer, the hardest part is getting financing. So the Reg D, private placement, you wouldn't recommend doing that?
Would recommend doing what, I'm sorry?
The Reg D private placement? The private placement that was given?
I wouldn't begin to try to give you advice on that. Every lawyer I know will not answer a single question on securities law and says, go see a securities lawyer. I don't know. Do you intend to market a project as an investment contract to people saying this is
Well,
really
I
great,
mean,
you're
like
gonna make
if
a
you were
bunch of money?
gonna, purchase a shopping center,
I'm sorry?
if you were gonna purchase a shopping center, say, that you would just do a Reg D private placement to raise your capital to be able to purchase it.
Yeah, I wouldn't begin to know what registration requirements are good or bad or indifferent or required or exempt. I
Do
just
you know if
don't.
that's common, or
I'm sorry?
do you know if that's common or uncommon, or?
Just don't know, just
Okay.
don't know. I'm sorry, it's not that I don't want to be responsible for an answer, I just plain don't know. Because I've always said, leave that to the experts. Like brain surgery and other stuff, I'm just not, not going there. It's way too specialized an area of the law. Any others? Okay, we've got 2 chapters on leasing. And then we've got a form lease to discuss, as you know. I'm gonna try to keep this moving, and because we're falling way behind time-wise. Feel free to stop me if you have a question, but I'm gonna try to get through this as quickly as I can. The first chapter, chapter 7, is about the lease itself. The concept of what is a lease really, and what does it mean? Excuse me, as we're going to allude to, Florida has a chapter 83 that regulates leases, but it doesn't really define what is a lease. So we're going to talk about that concept first. A leasehold estate is what you get under a lease. Like a life estate. Well, this is a leasehold estate. And that's what happens when an owner, and the materials call him a lessor, but I'm not going to use that term. I call him a landlord, conveys a possessory interest in the property to a lessee, I call him a tenant, for a specific period of time in exchange for the tenant agreeing to pay rent. So the tenant is buying the right to possess a piece of property for a specific period of time. That's what a leasehold interest is, or a leasehold estate. Now, of course, the document you do it with is a lease, but that's to follow. There are several different types of leasehold estates. The first one is called a term tenancy. Term, T-E-R-M. And that's when you have a very specific period of time with a specific start date and a specific ending date. That's a term tenancy. That's what you usually have. The next most common is a periodic tenancy. And that's what you hear about as a month to month, or a week to week, or a year to year. It's for a period, but then it continues for that same period again, and again, and again, repeating. And it can only be terminated by proper notice from one of the parties. And then we have statutes that say what's proper notice. You know, how long in advance has it got to be? We have a third type that's called tenancy at will. At will. And that is simply it continues until somebody terminates it. No required notice, just I'm done, it's over. Either side. That's a tenancy at will. And then we have a tenancy at sufferance. And that's basically, the materials say, a trespasser. Person that has no right to be on the property at all. Now, it doesn't usually happen, a trespasser. It usually happens as a result of a term of a tenancy has run out and the tenant doesn't go. It's a holdover. And that person who stays, that tenant who stays in possession beyond the expired term is called a holdover tenant. Now, a holdover tenant is not a type of leasehold. The type of leasehold for a holdover to stay is a tenant that suffers. The materials are a little confusing on that. But a holdover tenancy is not a type of tenancy. Okay. Those are the four types of leasehold estates. Yes, sir?
How does squatters' rights kind of relate to that?
Nothing to do with any of this.
Okay.
Squatters' rights is a whole different concept that has nothing to do with a lease.
Okay.
It's not a lease. It's just a squatter.
Okay.
Different issue about what rights he obtains and all that, but he never gets a lease.
Okay.
Okay, a lease. A lease is the document or the agreement, because a lease can be oral, but a lease is the agreement that creates a leasehold estate. It transfers the possession right from the landlord to the tenant, subject to certain time limits, and that's of course what determines what type of tenancy we have. But the document, a lease, is a contract. Now, since a lease is a contract, it's got to meet some of the same requirements that any contract has to meet. We're going to discuss these at greater length, and I'm not going to go into them now when we discuss contracts. We've got a chapter coming up next time on contracts, and then a separate chapter on real estate contracts. But like any other contract, a lease has to meet the requirements of a contract. That's things like, you don't need to know these yet, consent and consideration, and we understood each other, and we all knew what we were doing, and we really intended to make a deal, and all that contract law stuff, which is not what this is about. But a lease is a contract and has to meet those tests. In addition, a lease, because it's a contract, is subject to a law we have in Florida, and we have the same law in every state, that's called the statute of frauds. And what the statute of frauds says is that any written document that conveys an interest in land which can last for 1 year or more must be in writing. Has to be written. So we've said you can have oral leases, and you can. But you can't have an oral lease that lasts more than a year because of the statute of frauds. And that doesn't mean two of you can't have a verbal lease for 10 years. Sure you can, but you just can't enforce it. The statute of frauds says that no agreement relating to land to last over a year may be enforced unless it's in writing. And the purpose of that obviously is to protect against fraud. That's why it has that name, statute of frauds. Since you're going to therefore have a written document, landlord and tenant both have to sign it, because the law is very clear that a contract cannot be enforced against somebody, a written contract, unless they signed it. You can't write up a lease between landlord and tenant and only have one of them sign it and say it's binding on the other one. It's not. They both got to sign it, like any contract. A lease is going to describe the premises, and that premises is an important legal buzzword. It means the same thing as property, like when we looked at a sales contract and we talked about what's the property, and we're going to talk about that at much greater length when we talk about specifically sales contracts. But all throughout this course, and most of your real estate discussions, you're going to be talking about the property. But when it's a lease, it's called the premises. I don't know that anybody knows why, but that tells you you're talking about a lease when you discuss the premises. A lease is going to have a term, we know that. It's going to have parties, landlord and tenant. It's going to have premises. It's going to have a term. And it's going to have rent. And usually, and the best way to talk about rent, and we'll see this when we look at a lease later, is to say, what is the total rent for the term of the lease? And how is it payable? In other words, $12,000 payable $1,000 a month for 12 months. Okay. A lease should describe what use the tenant is going to make of the premises. In a residential lease, that's pretty easy, but it's usually going to say, to be used by the tenant as a residential home, da-da-da-da-da-da. That's pretty clear. If a lease doesn't say anything at all about the use of the premises, then a tenant can use it for anything whatsoever that's lawful. If the tenant uses it for unlawful purpose, he's violated the lease, even if it didn't say what the use was, and the landlord can terminate the lease. Here's where use gets real important, though. When we get into commercial leases, it gets to be hugely important. For use as a restaurant, for use as a bookstore. And that becomes doubly important when you get into the law of exclusive uses. For example, when you own a shopping center and you lease to Publix, Publix says, we have the exclusive right to be a shopping center, to be a grocery store. There will be no other grocery stores in this shopping center, or the exclusive drugstore, or the exclusive bookstore. So it's important to a tenant to get an exclusive use, but realize it's also important as landlord that you limit every other tenant so he can't do those uses. Saying to Publix alone, you get to be the only grocery store, is no good at all if you do leases with everybody else and don't specify their use. Hell, they can all be grocery stores because it's legal. So you gotta go all the way with it. When you give somebody an exclusive, you gotta make sure you keep anybody else from being able to carry on a competing business. And the way you do that is you don't say in every other lease, by the way, you can't be a grocery store. You just tell them what they can be. On and on down the line. And that's why often you won't see two bookstores in a shopping center.
Or two banks.
Because it's been prohibited. One guy has already gotten a lease that said you get to be the exclusive bookstore. Sometimes people look at this differently. Coral Springs has an auto mall with all these kinds of auto dealers all there together. Some people believe it's a great idea to bring people together with all the same kind of business, and then everybody who wants to buy a car will come out here. But if you had a whole shopping center of nothing but guys selling books, it's probably not going to work. So use is real important, not only because you as landlord want to limit what the tenant does with your piece of property, but you want to be able to market to other tenants that they can have exclusive rights too, just like this guy maybe did. Now, the fact that you said to this guy, he can only be used as a bookstore, all by itself, that doesn't give him an exclusive. That doesn't say you get to be the only bookstore, unless you say that too. You're limited to a bookstore, and I as landlord agree you will be the exclusive bookstore, and there'll never be another bookstore in the shopping center. That's an exclusive. And then you better enforce it with everybody else's leases, telling them what they can do, which does not include being a bookstore. Yes, sir.
By any chance, does that have any implications on like
I'm sorry, say again?
Does that have any implications on the First Amendment right to what is it, free speech, I think it is?
I don't think so.
Because essentially you're restricting what a person can, how a person can express themselves.
Yep.
Through business.
Yep. And that's what I think a property owner has the right to do with a tenant. I don't see any problem there whatsoever.
So how come
We're not
there's,
telling him you can't go out and yell fire in a crowded theater or any of that kind of stuff.
what I mean is, so then how is zoning a problem when they limit strip clubs or something like that? Like,
Well, no, you're talking about, zoning is police power.
Yeah.
And that's government.
Mhm.
That's a different subject that we'll talk about another time. We're talking about private restrictions imposed by a landlord in a lease.
but can that private restriction pose an issue to the amendment right to
Not
to
in my
free
opinion.
speech?
In my opinion, no.
Okay.
I've never heard of it doing that, and candidly, it doesn't make any sense to me
Okay.
to apply free speech to what type of products you can sell. on
Well,
the street.
essentially, if I'm a landlord, I say, hey, you can't put a strip club in my place.
Sure, for two reasons. Number one, it may violate the law, maybe.
I'm saying if it's legal,
Okay.
if zoning allows me to put a strip club here.
The fact that zoning allows something to take place does not mean that you have to do it, or that you as landlord have to allow it.
Okay.
The fact that I might be allowed to build a strip joint doesn't mean that I'm going to,
Mm-hmm.
and doesn't mean that I have to let my tenant build one either. Because
Okay.
a lease is a contract, and a lease can specify a use for the property, and the landlord can enforce it.
Okay.
And rent, frankly, rent is often determined by the use that you give the tenant, and the profitability of that use, and what kind of income that might generate in order to pay the rent. So that has a lot to do with basically the whole concept of the lease in terms of what the rent is. I don't see any First Amendment implications whatsoever. Any others? Okay, now, materials touch a little bit on whether or not a lease should be recorded. It's a very complicated issue in Florida. Basically, you don't want to do that. Would never arise in a residential situation anyway, but in a commercial situation, it's not a good idea if you're the landlord. If you're the tenant, you might want it recorded for certain reasons, but basically, you don't record leases. Excuse me. And there's some exceptions to that, but they're not worth going into. Now, commercial leases. Haven't opened up that concept with a talk about exclusives and everything, I want to talk about commercial leases. I think loosely, we've probably been thinking about residential leases as we've gone forward in this talk, and that we're all thinking about renting a house or renting an apartment. But obviously, commercial leasing in this country is huge, and I want to talk about commercial leases and about what the materials set forth as the 4 types of commercial leases. And they're all kind of based upon the rent, but not totally. But one point that I want to make that I want to make sure everybody understands, and may not be aware of, that rent in Florida on commercial leases carries with it sales tax. And a lot of people don't know that. And a lot of people get in a lot of trouble with the Department of Revenue over it. You pay sales tax on commercial rent just like on buying a pack of cigarettes or anything else. 6, 7, whatever your county is, % sales tax like regular sales taxes on all commercial rent. You also pay it on residential rent if the lease exceeds a year in term. And that's why nobody signs residential leases for more than a year. Otherwise, they'd have to collect sales tax on those too. Okay. There are basically 4 types of commercial leases. One is called the gross lease. And all the gross means is tenant pays a fixed amount of rent, and that's intended to include everything. He doesn't pay anything else. Now, he does pay sales tax. In each of these examples, I'm going to forget sales tax. But the concepts we're talking about are other operating expenses that the tenant might have to pay. In a gross lease, you pay $1,000 a month and that's it, period. That's all I'm paying, plus maybe my sales tax. Landlord pays everything else. The next type is a net lease. And in a net lease, the tenant pays some or all of the operating expenses of the property. We're talking here about taxes and insurance and maintenance. Now, as the materials talk about, and you'll hear people in the industry talk about, there's a double net lease and a triple net lease, and they call them a net lease and a net lease. And all they're talking about is how many of these expenses are paid by the tenant. In a net lease, the tenant pays the taxes. In a net lease, the tenant pays the taxes and insurance. In a triple net lease, the tenant pays the taxes and insurance and the maintenance of the building, of the building, really. We are really so far talking about leases that include a building. Okay? Net lease, and whether it's a double or a triple net lease. Now, for whatever reason, and I don't have a clue, it's like a spaceship came in and landed out of left field here. In the book, they right in this section, talk about a 1031 exchange. I kind of went, what?
This book does that a lot.
Yeah, okay, yeah. This to me was the worst example I've seen yet. We're talking about all different kinds of apples here, and now it's just, oh, by the way, here's some oranges, you know. Forget this. We're going to talk about it later a little bit when we talk about commercial real estate sales. But this has nothing to do with leasing. A 1031 exchange doesn't even have a lease in it, you know, so as to being comfortable of what you're not responsible for from examination purposes, for God's sake, forget about that. Okay. The third type of lease, commercial lease, is a ground lease. Now, in a ground lease, pretty much what it sounds like. It's vacant land. Landlord leases to tenant a vacant parcel with the expectation and frankly with the obligation in the lease that tenant at tenant's expense is going to build a building there. Of course, that building technically is owned by the landlord. The building is a fixture. It's a part of the land like we talked about. The tenant's going to build a building on that land. The rent, of course, is only going to be based on the value of the land because the tenant paid for the building. So he's certainly not going to pay the value of, you know, the square footage and all that kind of stuff in the building. He built the thing. It is a net lease because in addition to building the building, the tenant is going to pay the taxes. And there's a real good reason for that. Because the amount of the taxes is going to be based on the value of the building that the tenant built.
Right.
So you sure as hell couldn't have the landlord paying that. And he's going to pay the insurance on his building that he built. And he, the tenant, is going to pay to maintain his building. So it is a triple net lease where only land is leased by the landlord. And the tenant builds the building at the tenant's expense. Okay, one more. It's called a percentage lease. And as we talked about, a lot of these are kind of based on how do you pay the rent. That's how these labels come in and how they're differentiated. In a percentage lease, remembering we have a commercial lease, the tenant is going to conduct business on the property. And usually it's going to be retail, and usually it's going to be sales. Restaurant, sale of goods, merchandise. The rent is a portion of the sales made by the tenant. So the landlord is kind of participating here in how well the tenant does. If the tenant does real well, the landlord does real well. If the tenant does poorly, well, the landlord doesn't do so well. Usually, here's what they say. They'll have a low base rent, under market, a building that might be worth to lease, that's a bad example, a building that might be worth to lease $3,000 a month. You lease it to the tenant for $1,000 a month. And for 10% of his gross sales, not his profit, for 10% of his gross sales over $5,000 a month. So maybe if he has sales of enough money to yield a good bit of additional income to the landlord makes up that kind of discounted differential by an under market rent. And if the tenant does real well, the landlord does better and better. It's not a partnership, but it looks a little bit like it because you're both participating in the profit. You're not participating in the profits, you're participating in the sales of the tenant. God forbid if it got into profits and all the math that were involved in calculating what's his profit and everything, it'd be a nightmare. We'd never get there. It's tough enough. It's tough enough to enforce these things against a tenant based on his gross sales. And the way they're done is tenants file sales tax returns based on the amount of sales that they've had and use those tax returns, but we all know that tenants may do cash sales that don't get reported on the sales taxes, so it's really hard to enforce this stuff. But it is a good way for a landlord to do very well if he puts a good tenant in there and does well. And it's a good way for a tenant to protect himself in bad periods of slow sales against a heavy rent that'll kill him and put him out of business, but pay more rent when he can afford it. Okay, those are commercial leases. Those are the 4 types of commercial leases. As you can see, they're largely based upon how the rent is structured. And with one other concept, we're done with, as far as I'm concerned, this first chapter on leasing, chapter 7. The concept of renewals. Yes, sir.
Are out parcels on shopping centers typically a ground lease?
On shopping centers, aren't they?
Are out parcels on shopping centers, are those typically a ground lease?
They can be done in any different ways. Often they are ground leases, yes. Very often they're ground leases. But very often also, you'll see a landlord have a sign out there called build to suit.
Yeah.
And build to suit would not be a ground lease. It's I, the landlord, will build you a building according to your specs. But then I will lease it to you based upon my cost of the building and what the building is worth. You'll then be paying either a gross rent or a net or a percentage lease of that building. But in all cases, the value of the building is built into the rent because as landlord, I built it for you. Whereas in a ground lease, the rent would be less because you, the tenant, built the building. That make sense?
Yeah.
Okay. Yes, sir.
Yeah. What's considered out parcel? Is that like the loading bay?
I'm
What's
sorry.
an out parcel when you start?
You said an out parcel?
Yeah.
Do you not know what an out parcel
No,
is?
I don't.
An out parcel is kind of a freestanding, usually a freestanding building out front of a shopping center. A Hooters restaurant sitting out front of a shopping center.
Oh.
Freestanding, separate, not attached building. But it is a part of the shopping center, but like it's not part of the mall. It's not part of the strip. It's a separate parcel that you can have you can have it separately assessed for tax purposes so that you can determine what are the taxes on that parcel and have the tenant pay them, whether in a net lease or even in a ground lease, or you can carve it out as a ground lease and just have it be a piece of, you'll often see them when somebody builds a center and out front, maybe there'll even be some dirt. Often they won't even pave it because they're waiting for the tenant to come in and put down his building pad. And very often it's out front. Sometimes filling stations are out parcels sitting out front of a shopping center. What it really means is it's part of a big piece owned by somebody, all owned by one shopping center owner. But it is not developed as a part of the mall or strip or whatever. They're independent building pads.
Okay.
Okay, yes, ma'am.
I have a quick question. I always get mixed up when these are mentioned. The absolute triple net lease,
Uh-huh.
and I've heard complete triple net lease. What?
I've never heard either one of those terms. I've heard just triple net lease. An absolute and a what?
Absolute triple net and complete.
Yeah, and what was the other one?
Complete triple net.
I can't imagine how either of them would be any different from a triple net lease.
I've heard them before, and I've always meant to ask what.
You don't know what the difference is between them though? No, neither. Sorry. I've never heard of them. I don't have a clue. Yes, ma'am.
Yeah, the book states that giving the right of position to the tenant and making a difference.
I'm sorry, say again?
The book, at the end, it says about what's the difference between giving the right of possession to the tenant or giving possession of the land to the tenant. Isn't it the same thing? Giving
I
it
don't
the-
see any difference. I don't see any
Okay.
difference. There was a weird little distinction made in there about whose problem is it if when the day of the lease is set to begin and there's somebody else in there. And it talked about, then the landlord can't really deliver possession because somebody else is in there. And the book went into distinctions about whose job is it to sue that guy who shouldn't be in there to make him get out. It's a little too obtuse for me. I wouldn't worry about it.
I think it was the difference between the right to possession and actual possession. The right to possession is signed over in the lease. Actual possession is when you actually, if there's a tenant in the building, get the tenant out of the building and turn over actual access to the building. That's what I understood from it. Actual possession is when you give him the actual building. The right to possession is when you sign the lease.
Makes
Which
sense.
may or may not involve actual possession at the same time. If it's empty, it might be right now.
Yeah.
If the lease commences next month, probably not.
Yeah.
You're right. There's a good technical distinction, but in all candor, I don't think it'll ever affect us. Yes?
When you go through the eviction process in a commercial lease, how is that different than residential?
When you go through the eviction process, how's it different from what?
From residential?
From residential versus commercial?
Yeah, is it,
We're gonna get into that in the statute. We have Florida statutes that are all about that. And at the end of the document that I sent you is the residential portion of the statute. In either case, and know this if you would, I hope this goes without saying. If the tenant is still in there in Florida or anywhere, if you want to get the tenant out, you got to file a suit and have the court order him out and have the sheriff remove him. If you do it yourself and basically grab his stuff and throw him out, you set yourself up for a terrible lawsuit, like painting a bullseye on you. As not the case at all if the tenant is vacated and beat, if he's gone. But there is no self-help eviction in Florida without huge liability attached to it. Bad idea. Okay, last thing in the chapter is lease renewal. The book wants to make the distinction, and it's technically correct, but it's a little confusing, that when a lease runs out and the term in a lease is over, that you can renew the term, which really means extend the term. What's confusing is, and this is legally correct, when you renew a lease, that creates a new lease. His first year term has run out. We've agreed to renew it for another year. Technically, that creates a whole new lease with a whole new term. But people don't go sign another lease, is the point. The point of a lease renewal is the same terms apply here. And if you do it again, and apply here. And here's where it becomes common. In commercial leases, you're going to see all the time renewal rights in favor of tenants. It'll say something like, tenant has 3 options to renew of 3 years each. and it's hugely important. A tenant needs to, a commercial tenant needs to have that right. What's the purpose of working like hell and building up your business for 3 years and building up a whole huge clientele and goodwill if at the end of 3 years you gotta get out? You wanna stay, and you wanna know you're gonna have the right to stay. So as a tenant, you build into the lease rights of renewal, lease renewal rights. I'd like to be able to renew for 3 more years. And if things are good, 3 years after that. But I also need to know that if things are going badly, then I'm done. So realize that a 3-year lease with 3 3-year renewals is kind of like a 12-year lease. But the tenant gets to decide every 3 years, do I want to go for another 3 or do I want to quit? The landlord would rather have a 12-year lease and the tenant's obligated for 12 years. The tenant would rather have a 3 and 3 3s. So he can quit at years 3, 6, or 9 if things are going badly. But that he's covered if things are going well, that he doesn't have to pack up and move and lose his customers and lose his goodwill and incur all the costs of moving. That's a lease renewal. Again, the book wants to make the concept that it creates a new lease. Each of those terms is a new lease. Yeah, it is. But you don't sign a new document. You use the same document. Now realize also, probably, the rent's going to go up in each of those terms. Landlord's going to say, yeah, but the rent's going to increase 10% or 20%, and the next time another 20%. Landlord's got to cover himself. If the landlord signed a 12-year lease, he'd have escalators built in. So certainly in those renewals, he's not going to say renew without change. But if a lease did have renewal provisions, and if it did not change the rent, then the rent is staying the same. Because all of the terms in a renewal term are the same as the lease they renewed, unless it says otherwise. Okay?
Isn't that extremely important in like a ground lease? Like having the right to renew?
Well, as a tenant, you want very much the right to renew.
I mean, in a ground lease, that's really important, right? Because if I'm coming to build a building on this land.
Oh, in a ground lease?
Yeah.
Oh my God. Ground leases where you're going to build a building, I've never seen one for less than 20 years.
Oh, okay.
And then they always have renewal terms after that, true.
Okay.
Often they renew out to 60 or 80 years. Commercial people who build on a ground lease like that, I think the target that I usually see is 40 years, grand total they're looking for. They'll sign a 20-year lease with 4 or 5-year options to renew.
Okay.
Over the 40 years, they have certainly fully depreciated the value of the building, and probably it's become worthless. So the concept that at the end of the 40 years, they build a building and the landlord owns it, you know, it's a 40-year-old building, you know. It's hugely important. But the 3333 example that I gave you, you would never do that in a ground lease as a tenant. You would never build a building and only have even that short a term. Mm-hmm. You'd want a fixed, normally 20 up front.
Yeah.
And then maybe 3s or 5s after that, going out at least 30 years, but maybe 40 or 50 in the aggregate in the grand total.
Mm-hmm.
And that ground lease usually escalates? The ground lease usually escalates?
Yes, usually does. And often contains a percentage clause, because it's usually going to be a retail tenant building it. So often we'll have a percentage of sales clause in it too. And an escalator. But the landlord, realize that the landlord is protected there against the increased taxes and the increased insurance because the tenant's paying them anyway. So what the landlord is really trying to capture is basically the appreciating value of his property and the deflation value of the dollar. That's what he's trying to protect against in those increases, but at least he's covered for tax and insurance increases because the tenant's paying those anyway. Okay.
Question.
Yes, sir.
So what happens at the end of your term?
It's over.
Let's say you have like you said the example, you have 3-year and then option to renew after every 3 years.
Mhm.
And do you need to have, is there any, is just a verbal correspondence between you and the landlord as, okay, I'm gonna continue?
Oh, well, you'd sure start talking about it if you were facing calling a moving van, you know.
Right, so, but you don't have to sign any documents, you're saying?
And it's a renewal.
You sign a, you just sign a renewal, it's the same lease. but you
Here's
sign
what
a-
happens in a renewal. The renewal paragraph will say, tenant has an option to renew this lease for 3 years.
Mhm.
In order to exercise his option, tenant has to send 90 days notice prior to the end of the term to exercise his option, or he's waived it. But that's it. Then there is no further documentation signed, because the lease right in it
Right.
has built in what the rent's gonna be, what the start date's gonna be, what the end date's gonna be, all the other boilerplate is what we call all the other mumbo jumbo crap, that's all already in there anyway, all the other stuff.
Right.
So really, all you're doing is a tenant sending a piece of paper that says, I exercise my option to stay 3 more years. And everything else is already in the lease. Okay, so according to the concept of the text, yeah, you have a new lease, but you don't have a new document.
Right.
Okay, no. Next chapter is the concept is more about leases, obviously, excuse me, but it's explaining the landlord and tenant relationship. And what it's trying to show is that, I'm not big on history, but that historically, landlords were very favored in the law, and that the trend in the law is swinging in favor of tenants constantly, and constantly moving in that direction, especially in residential tenancy. Somewhat in commercial, but hugely in residential tenancy. The law is swinging in favor of residential tenants, and you'll see that in the Florida statutes. We have a monster law regulating residential tenancies. We have about 2 pages on commercial tenancies. The law presumes that commercial people are sophisticated and know what they're doing, and it doesn't need to look out for the tenants' rights there. Residential situation, not so at all. Both the courts and the legislature lean over backwards to protect residential tenants. So, in that regard, Florida has the Florida Residential Landlord and Tenant Act. It's part 2 of chapter 83 of the Florida statutes. We're going to go through that.
Can you repeat the name of it, please?
Part 2, chapter 83, Florida
Residential
statutes.
Landlord and Tenant Act.
And the lease that I sent you, it's the last 10 pages or so of the lease, is exactly this, same thing, part 2, chapter 83, Florida statutes. Okay. There's just kind of a bunch of loose concepts flying around here in the chapter, and frankly, I don't see them as flowing in any particular order or sense of order. So I'm just going to throw them out there, and we'll move through them as quickly as we can, and then see where we are in terms of getting into the lease time-wise. First concept is to explain to you that landlord wants some security. The concept here is, oh gee, landlord's taking all the risk. He's letting the tenant have his piece of property for a period of time. What can he do to protect himself? There are basically 3 things. The first one's a given. You collect your rent in advance. If a lease didn't say so, and if the statute didn't say so, which it does in residential areas, basically rent would be payable at the end of a lease term. Law used to be that way. Courts always used to say that, hey, the tenant has to get to live there for a certain term, and then he pays his rent. He hadn't gotten his goods yet. Well, all landlords want it the other way around. They want the rent paid in advance. And the reason is, number one, I'd like to have my money, but number 2, if you're in trouble and the tenant ain't gonna pay, the sooner you find out, the better off you are. Rather than at the back end when the tenant's already been there the whole term. So, one of the things landlord does to protect himself is gets his rent payable in advance. That's pretty standard, but a lease has to say it if it's commercial. Residential is built in. Second thing a landlord does, get a security deposit. Now, everybody who's not in the leasing business that I know of thinks of a security deposit as a damage deposit. What if a tenant breaks a window? What if he puts his fist through a wall? That's only part of what a security deposit is. A security deposit is money held by a landlord in case the tenant defaults in any way under the lease. If the lease is written to say that it only covers when the tenant breaks down doors and windows, well, then that's all it covers. But if it properly says to cover any default by the tenant under any of tenant's obligations under the lease, then it covers rent and damages and other things that the tenant was obligated to do. That's called a security deposit. Sometimes you see it called a damage deposit, and if it is, it's a very limited deposit. All right, the third thing that a landlord can do to protect himself is get a guarantee. Now, just like we talked about, if a bank's loaning money to a corporation, and the corporation didn't have any assets, the bank's going to want the shareholders to guarantee the loan. Here, if you're going to rent an apartment to somebody who has bad credit rating, ostensibly, visibly has no assets, as a landlord, you got to wonder, how am I going to get paid? You get a third party to guarantee the lease. You get mom or dad, or employer, or somebody's best friend who has a good job, to sign a guarantee that says, I promise to pay or fulfill the tenant's obligations if the tenant doesn't. That's called a guarantee. And just so you'll know, it's spelled both ways. With a TY or a TEE, and you see it interchangeably all over the place, and even within the same document, you'll see people going back and forth. But it's by a person who's not the tenant. Somebody with greater financial strength than the tenant who guarantees the tenant's performance. All right, that's three things a landlord can do to protect himself. Then the book shifts into what it calls the landlord's obligations under a lease. Now, some of these are obligations from common law, basically saying any landlord has these obligations, which would be commercial or residential. And some of these come right out of these Florida statutes, saying these are obligations a landlord has. The first one, and this is everywhere, this is called the covenant of quiet enjoyment. And what that means is landlord guarantees that the tenant will have the premises for the term of the lease free from interference by anybody else. That's really what it is. If it doesn't happen, tenant has a cause of action against the landlord. Somebody comes in and kicks the tenant out, for some reason, the tenant gets to sue the landlord. It violated the covenant of quiet enjoyment. Okay, the next one we started on a little bit earlier, the covenant to deliver possession. The landlord covenants, agrees, promises that he will deliver possession to the tenant at the time the lease is scheduled to begin. Now this, as I recall, is where it gets off into, yeah, but what if there's somebody else in there? I don't think it's worth beating this horse to determine what happens then. The next one, and this is
Before you
residential.
actually do it, sorry. It says the tenant has the obligation to evict the.
That's what the clause says, believe it or not. As stupid as that sounds, that's what the court said.
Okay.
That's why I didn't want to get into it. The next one is called the covenant of fitness of the premises. And interestingly, and it says the next one is the implied warranty of habitability. And they both say that the landlord guarantees that the premises are fit for habitation, are safe and sanitary, and suitable for somebody to live there. I don't see the distinction between the two. It suggests that there is one, but I can't find it. But know if you would, these of course are only residential, and they are imposed by our Florida residential statute. Obviously, if you lease somebody a filling station, you don't warrant that it's fit for habitation. This is all about residential stuff. Now, there's the concept of the duty to repair. But for the statutes, which impose upon the landlord obligation to repair certain things, like rodents, bugs, certain safety things, there is no obligation on the landlord, generally under a lease, to repair the premises. And often we talked about also under a net lease or a ground lease, all those repair obligations are stated and are dumped on the tenant. But there basically is no obligation of a landlord unless it's required by statutes, and you're going to see as to some things it's required by statute. The duty to pay taxes, interestingly, real estate taxes, the law is very clear, is payable by a landlord. Unless, of course, under a net lease or a ground lease, it was put on the tenant. But absent any statement, it's landlord's duty to pay taxes. Interestingly, though, if there's a tax on the rent, that's payable by the tenant, because that's sales tax. And the buyer always pays a sales tax. So he who's writing the check there, if it's a tax on rent, pays sales tax. And of course, mechanically, so you'll know how that works, I'll be there in 2 seconds. Just like anything else, if your rent is $1,000, you write a check to your landlord for $1,060. And then once a month, the landlord has to send the $60 in to the State Department of Revenue. Just like you pay sales tax to Target, and they have to send it in. Mechanically, it's the tenant's obligation to pay it, but he pays it to the landlord remits it to the Department of Revenue. Yes, sir?
About the duty of repair, to repair, you said that the landlord does not have a duty to repair the premises, correct?
I'm sorry, the landlord should not, what, I'm sorry?
Should not repair the premises?
Is not obligated to repair the premises unless the lease obligates him to, or unless a statute
Because I've seen
obligates him
leases
to.
that, for example, it says that if you have a repair that's over $300, X amount, it's obligated to the landlord.
Well, what we're saying is what the lease agreement says. What you and I are talking about is what a provision in a lease agreement may say. We're going to look at this lease form that I sent you, and you're going to see, and it's very well done in there. This is another one put out by the Florida Association of Realtors. They list every possible thing that could ever have to be repaired. And then you put a little check mark next to it, who's going to repair it, landlord or tenant. But the point is, that's by contract. By lease, by contract, you decided who was going to pay. The point the materials are trying to make is, unless the lease says so, or unless the law says so, a statute, otherwise there is no obligation on the landlord to repair it. Yes, sir?
What's the difference between a lease and a rental agreement?
Nothing, no, nothing at all.
You're talking?
Nothing whatsoever. Both are contracts. You see the terms used interchangeably. Sometimes at the top of the page it says one, sometimes it says another. But there's absolutely no difference. Okay. Now, although we said the landlord has no duty to repair, the law in general requires him to do one type of repair, if it's repair. The landlord is obligated to see that the property meets all of the city building codes. And that's for health and safety reasons. That means fire protection. I can't think of another one at the moment. Stair railings, railings on balconies, things like that that are required by the building code for the health and safety of visitors and tenants. Those obligations fall on the landlord, no matter what the lease says. Okay, now the book shifts in. Well, by the way, rent. There was a concept in there about rent control. You don't need to know that. Basically, we don't have that in Florida, except certain HUD housing apartments and stuff like that. But we don't have the general concept that the book is talking about, where every apartment building in New York City has rent control. We don't have that. Yes, sir.
So what, the tenant just doesn't have to pay if the building's not in compliance, or?
I'm sorry?
If the building's not in compliance, the tenant has a legal right not to pay rent?
No, what I'm saying is the landlord cannot compel the tenant to make those repairs. The law imposes those requirements. And when a building inspector comes out and cites the building for not being in compliance, it's the landlord who's going to have to pay for it.
Okay.
And that creates a lien against the property. And of course, the lien against the property is of concern to the landlord anyway, so he's going to end up having to eat that.
Okay.
All right, the book shifts now into landlord's remedies. This is what happens if the tenant violates a lease. These are pretty obvious, and I think everybody knows what they are. The first one is eviction. You can file a suit to have the court order the sheriff to evict the tenant from the property. Now that's normally we think of because he hasn't paid his rent, but it's not limited to rent. Limited to any violation of the lease. But, as we talked about, don't do self-help there if the tenant is still in there. Don't remove a tenant yourself. You got to have the court do it, or you become liable for huge damages far beyond anything you were ever thinking of going the other way. The other thing that you could do is sue for rent. Basically, get a money judgment against the tenant for rent, or for the damages, if the damage was other than rent. And remember, that means might have a third party on a guarantee, so he might be suing the tenant and the guarantor. And he might be a lot happier suing the guarantor and collecting the rent than having the tenant evicted and have an empty apartment and no money. So sometimes it's a preferable remedy would be suing for damages, but only if you think you got somebody you can collect from. One concept is mentioned here, and it's called mitigation of damages. And all this simply means is that if the tenant moves out and the landlord reclaims possession of the premises because the tenant moved out, and the landlord sues for rent, the landlord is required to mitigate the damages, meaning try to lease it out again and collect some rent for some of that period that the tenant moved out on. Use your best efforts to release the property. And don't just plain old leave it empty because you got somebody to sue for it. You are obligated to make a good faith attempt to mitigate the damages by releasing the premises, if you're suing for damages. Okay, now we got the tenant's obligations. Shifting gears. Tenant has the duty to repair it. That means, in general, what that means is the duty to make such repairs as will return the premises to the landlord at the end of the lease term in the same condition in which they were at the beginning of the term. Restore the premises to their original condition. Tenant is obligated to do that. And often that's part of what the damage deposit is for anyway, the security deposit. Tenant is obligated to avoid waste. That means don't subject the premises to damages by letting them waste against the elements. What they're getting at is, don't leave the doors and windows open so the rain will come in and damage the building. Protect the building against natural elements. The book talks about a duty to insure, and that sounds a little strange because absent it being a net lease or a ground lease, where we talked about is the tenant's obligation to insure, even in a situation where the landlord is insuring the building, there's a concept that it's the tenant's duty to insure his business such that he can continue to pay rent. As a tenant, if you have no insurance, let's say you're running a cell phone store, you're selling cell phones, and somebody comes in and steals all of your cell phones, and you have no insurance, you don't get to say to the landlord, I don't have to pay the rent anymore, somebody stole all my cell phones. The law imposes upon the tenant the obligation to carry such insurance as will enable the tenant to continue paying his rent in the event of a catastrophe. Now, we're not talking about what if the whole building burns down. That's a totally different issue, and the landlord probably has an insurance policy to cover that. Not necessarily to cover the cell phones, but to cover the building. But there's an obligation on the tenant to carry such insurance as is necessary to enable him to pay the rent. Okay. And the materials then get into trade fixtures again, and we're not going to go there because we've already covered trade fixtures heavily in the talk about fixtures. Tenant can take his trade fixtures out at the end of the term. We know that. Now, what can a tenant do to sue the landlord if the landlord defaults? Well, tenant has an action called wrongful eviction. Now, it's pretty much what it sounds like. If something happens that causes the tenant to be evicted from the premises, the tenant gets to sue the landlord for wrongful eviction. I was wrongfully evicted from the premises. There's another concept, though, called constructive eviction, and this comes about more often. And this is a defense by the tenant when the property gets into such disrepair that the landlord has not taken care of the property as required on the lease, that the tenant says, I have been constructively evicted. That's where the tenant gets to say, Your Honor, he made things so bad, it's just as if he threw me out because I can't stand to be here anymore. I have been constructively evicted from the premises. And that's a tenant's cause of action against the landlord for the condition of the premises that make them untenable, and usually in that case, a tenant will move out on his own, but he'll say, I was constructively evicted because the condition was not up to the requirements of the lease. There are three kinds of damages that are available to a tenant in a wrongful eviction or a constructive eviction case. And they are exactly what the three words sound like. Pretty simple. Damages, we all know what that is. Your Honor, award me some money for my damages. Reformation. That's asking the court to reform the lease, to change the lease based upon the landlord's default. I'd like to stay, but I'd like my rent cut in half, and I'd like you to reform the lease to cut the rent in half because the landlord is not fulfilling his obligations. Reformation, that's keeping the contract in effect, but reforming it, changing it. And the third one is rescission. Rescission, as we know, is cancellation. Rescind. Rescind the lease. Cancel the lease, let me out of the lease, declare the lease void because of the landlord's default. There's a concept that's raised now, and we're going to discuss it some more later as it's come up in the statutes. But the book now mentions that in some jurisdictions, while the tenant is suing the landlord, that the tenant is allowed to withhold his rent. That's not the case in Florida. Florida statutes, both in the commercial area and in the rental area, say the following. Tenant may withhold paying rent to the landlord, but it has to be paid monthly or whenever it's due into the court registry. Tenant doesn't get to sit back and just not pay. The tenant has to continue to pay the rent, pays it into the clerk of the court holds it until the case is determined, and then they decide what should happen to it.
It's like an escrow or something like that?
I'm sorry?
Is that like an escrow?
Like an escrow, did you say?
Yeah.
You can use that term for it. It's escrow is anything held by a third party until a condition is satisfied. You could call that an escrow. But the point is, our law is very clear. The tenant, if you decide to take it upon yourself and say, I'm not paying rent anymore, then landlord can have you evicted for not paying the rent. You have to pay it into the court registry. Okay. Now, interestingly now, the book shifts into something it calls third-party related transactions. And there's all kinds of different things going on here, but the common theme is we have a landlord and we have a tenant. And now we have dealings with third parties that relate to this landlord-tenant relationship. The first one is a sublease. Excuse me. And the definition is a little bit confusing because it gets off into reversionary interest and stuff like that, which sounds a lot like our life estate and stuff like that. What a sublease means is that a third party wants to take over possession of the property, but the lease is going to remain in effect. And what we do is we have a landlord have this lease with the tenant, and we have this third party that comes along, and we're going to put him in a sublease situation. And what that means is, this was the lease. We enter into a sublease agreement with the subtenant. So what's happening here is, the subtenant goes into possession, subtenant pays rent to the tenant, subtenant pays rent to the tenant. The tenant then continues to pay his rent to the landlord. This is our third party. What the materials are distinguishing here is if, for example, this was a 3-year lease, and at the end of a year, the subtenant comes along and says, I'd like to lease it for year 2. At the end of a year, I'd like to lease it for year 2. At the 3rd year, the possessory right is going to revert back to the tenant. Usually what happens, though, is the subtenant will enter into a sublease for the whole remainder of the term. And that's why it gets a little bit confusing, where the materials say, well, the possessory interest is going to go back to the tenant. But that's only if there's some term left. What's interesting about these relationships is understanding that the amount of rent here, I'm sorry, I'm having fits with this thing. The amount of rent here is not necessarily the same as the amount of rent here. And it can be over or under. If the tenant is stuck on this lease for 3 years, and it's $1,000 a month, and he's going to have to pay it even if he has to, his job transfers him somewhere else, he might be happy to have $800 a month from this guy just to help him. However, going the other way, it might be that the property is now worth $1,200 a month. So he collects the $1,200 a month, but he only has to give $1,000 a month to this guy. So the dollar terms of the sublease and the term of the sublease, both, can be different from the main lease. But the concept is, you've got a new party in possession, he's called the subtenant. The tenant is no longer in possession, but the tenant is still in the middle of what's going on, because